I'm Chris Finney. I'm a partner in Fox Williams Financial Services regulatory team, and I'm joined this morning by my partner Pollyanna Deane. Pollyanna joined us almost a year ago from Simmons & Simmons. Many of you will already know both of us, of course. We're going to talk this morning about the test case decision just handed down a few days ago from the Supreme Court. Just before we get into that, I'd like to just say a few preliminary words about background and how most insurance practitioners have been approaching this or seem to see it as we are at the moment. And then Pollyanna will talk us through the main parts of the decision. I'll talk briefly about causation issues, and then we'll have a look at some lessons learned and what insurers and reinsurers can do now in the light of this decision. So for background purposes and just briefly, I think it's fair to say that most insurers or insurance practitioners are looking until now to business interruption policies as if they were local policies. So they would respond if something happened at a property or very near to a property, and they would respond perhaps if whatever it was then moved out from the property or from the locality. But nobody really expected that they would respond if something came in, and especially if it came into the property or came into the radius of the property from the world or from the entirety of the United Kingdom. The FCA launched a test case to try to show that that was wrong. The High Court, in what to me seemed to be quite a strenuous sort of straining exercise, managed to find ways of finding that in truth these policies didn't only respond to local events and things that started locally and moved out. They responded in all sorts of ways. The FCA and the insurers appealed to the Supreme Court. The Supreme Court's managed to find a way of finding that actually more policies respond more fully than the High Court thought. And the result is now then that many more policies than most of us thought will respond, and they'll respond more fully than most of us thought they would. That doesn't mean, despite the headlines, of course, that every policyholder will be paid, nor does it mean that every policyholder's claim will be paid in full. And we'll talk a little bit about some of the limits on that and the ways in which the law still reins some of those in as we go through. One of the last things we'll look at then is what impact this decision might have. It's probably too early to know what the real impact will be. Pollyanna and I will talk about it perhaps as a case on its own facts or a policy decision rather than a case that necessarily makes new law. But before those things become clear, there are plenty of things that we can already learn from this, and plenty of things that insurers and reinsurers can already do to protect themselves against a proactive regulator or interventionist lawmaking courts in the future, if that's what they are. Just before I hand over to Pollyanna, I would just mention one thing. On your screens, you should have access to through the normal Zoom facilities a question and answer function. If you've got any questions, please do pop them in there, and we'll answer as many as we can on the way through, as many as we can in the time that's left at the end. It's quite possible that we'll go over a few minutes if there are a lot of questions, so that we answer as many of them as it's possible to answer in the time. So, Pollyanna, would you like to take us through the judgment?
Of course. Thanks, Chris. Thank you for the introduction. Good morning, everybody. Actually, it's afternoon, isn't it? So sorry about that. I looked at this judgment on Friday morning, and I have to say it completely spoiled the rest of my day. I was so grumpy. This is not a judgment that I feel is worthy of the Supreme Court, and it is great concern. I'm not proposing to go through the judgment on a word-by-word basis, because it seems to me that either you'll all have read it anyway, it's there for you to do so. It's not a wonderful read, it's not a great judgment. So fundamentally, I thought this session would be better to try and make sense of it rather than actually to go through it. So how do we make sense of this decision? We're going to go through that in the webinar, but for now, it looks like it's a policy decision. It's a decision made for policy reasons, and it's not really based on the law. And if it's going to be interpreted at all in the future, and I really hope it won't, it's a decision that's largely confined on its facts. Even so, as Chris said, it does give us some tools to work with. It highlights some of the risks that insurers face, and that we can use the case to address those risks now. I think it's really quite extraordinary, the first point in bold, that every wording tested responds to business interruption. But in fact, all those insurers were wrong. And I'll come on to this later, but how could they be wrong? How could all the insurers be wrong? This is just ridiculous. And when they looked at how to get to the answer they wanted, they actually had to even say the first instance judgment was wrong, which I had enough problems with. So it's really quite an extraordinary judgment. Look at how ridiculous it is when they're saying that essentially they're looking at the Arch Prevention of Access clause and suggesting that guidance rather than anything with the force of law was going to be deemed to have the force of law in order to extend the time, of course, that cover was available for. And they were saying in an emergency, government guidance can have the force of law. I'm sorry, but government guidance means in some cases don't eat pizza and don't smoke. If I ever thought that it was going to be a problem that don't smoke was going to have the force of law, it doesn't seem to be akin to guidance. Secondly, as I've said, the real problem with this case is that it doesn't follow the law. And one of the reasons why I think every insurer was found to be wrong was because the majority relied upon the case of Orient Express Hotels. And this was really quite recent in terms of 2010, and a decision that, while I'll come on to it because I think it's so important, while it was an outlier in some ways, it was also settled law. And I think it's very important that the case decides, instead of trying to make the case for changing the law and then changing it going forward, it actually changes it by acting retrospectively, which is appalling from a market certainty point of view. So I'm going to go on to the next slide. Thanks, Chris. And say, what do we learn from the Supreme Court that we can take away? Well, the first thing is that the case of Wood and Capita was confirmed. It's a Supreme Court decision, and the wording says that the core principle is that an insurance policy, like any other contract, must be interpreted objectively by asking what a reasonable person with all the background knowledge, which would reasonably have been available to them when they entered into the contract, would have understood the language of the contract to mean. Evidence about what the parties subjectively intended or understood the contract to mean is not relevant to the court's task. So far, so good. I have no issue with that. I think that's a very clear statement. The only trouble is that it's not actually what the Supreme Court did. The Supreme Court seems to have taken the view, as Chris said, that they wanted to get to the position where all the policies responded, all the SME policyholders were covered. And so we aren't convinced that the Supreme Court properly applied the legal principles that they professed to follow. Evidence about what the parties subjectively intended or understood the contract to mean is not relevant. So how come all the evidence about what the SME policyholders may have thought was deemed objective, and anything which might have been what the insurers thought was rejected? It's very strange. And the interpretation of the policies in that way means that they weren't objectively approaching the wording. They weren't looking at the words on the page. They wanted to get to a result. And whether or not you like that, it does seem very strange that the Supreme Court is taking more and more upon itself to decide what policy should be, rather than necessarily looking at what their role is as judges and looking at the policies there. This case makes assumptions about what the party was likely to have in mind when reading the policy, and then finds in their favour. I don't think that many policyholders would have actually had pandemics in mind. And quite apart from anything else, the insurers, if they did have pandemics in mind, sought to exclude them. I think it's important to learn from this that what the policies may have said doesn't appear to have constrained the Supreme Court much. What do we learn from this? I think it's absolutely clear to me on reading the judgment that the wordings are crucial. It's no longer possible to do dial a wording. This is not going to help. As Chris will come on to, some of those terms and words that we have assumed have a certain meaning in insurance law now no longer do, thanks to the Supreme Court decision, and your policies need to respond to that. The second thing I would say is that it is absolutely crucial to get your cover right, to stand back and say, what is it I'm covering and what isn't it? And I think we're going to see cover being much more narrowly defined and less reliance being placed upon exclusions. I think it's clear that the cover clause needs to be the fundamental motivator of your policy, and the insurer needs to stand back and say, what is it I'm covering? What is it I'm not covering? And only word it so that you cover what you want to cover. I think this is what I'm learning from this, and it's going to be a difficult exercise, not impossible, but certainly one that needs to be done, because I think, as I said in our previous webinar, the contracts are what insurers sell. This is the product. And if you don't get the product right, you're not going to be able to survive, frankly, in the market. Chris, can we have the next slide? So the Supreme Court decided to tell us how they decided what was agreed with the policy, remembering that Wood and Capita said that background knowledge was in there and it was important, and they confirmed that the High Court attached importance to the fact of the background knowledge. So what was this background knowledge? Well, there were 2 points I took away from it. One is that notifiable diseases might spread rapidly, widely and unpredictably, which seems to be fairly clear, though, as I said before, I don't think pandemics were in contemplation. And secondly, parties would be aware that government was likely to take action if there was a widespread disease, and we could expect some form of action to be taken which would constrain or restrict businesses, as we indeed did. But I don't think we thought that guidance was ever going to have the force of law. So I think this is a slight overreaction from the Supremes on that point. But perhaps the more extraordinary thing was the way they approached the but-for test and tried to, they actually tried to suggest that insurers would not have covered the cases within the radius because there were cases outside the radius. And I don't think that's what the policies were saying. I don't think they ever thought that they wouldn't provide payout for cases in the radius just because there were cases outside the radius. It was much more a case of looking at the wording and seeing what they came up with. Now, the but-for test has been much challenged, and certainly the Supreme Court were challenging it. But I think it's very difficult to see how you get away from it in terms of causation, and Chris will come on to this, because when the Supreme Court were desperately trying to find a way forward and saying that you can't even rely on the facts, I think it just shows the extent to which they were trying to twist this and suggesting that it was whimsical in terms of looking at policies that responded and didn't respond because there were cases outside the radius. I think that the Supreme Court is right to say the commercial reality would not have got them to that decision. But I do think it's important to remember that some of the but-for cases had been decided. And let's look at the fact that Orient Express had gone through with a but-for and had been found in favour of the insurers. So there was no reason to suggest it was whimsical, the way that the insurers approached the arguments. But the real shocker comes next. Chris, could I ask you to. Yes, I call this the benefit of hindsight, but I was tempted to call it the shocker, because this is what was entitled, what Chris sent to me and said, don't you think it's a shocker? Paragraph 190, which is actually the fact that there is this section saying that the context, judgments of fault of responsibility are not relevant, as I've just said. This matters is what risks the insurers have agreed to cover, hence the cover clause being absolutely key. We've already said this is a question of contractual interpretation, which must accordingly be answered by identifying objectively the intended effect of the policy as appropriate to the relevant factual situation. OMG. I really hope that this paragraph is not going to be relied upon. It's not going to be referred to in future cases, because having gone on about how wonderful Wood and Capita was, here you have the court saying it was objective, but that the intended effect of the policy, remember that, because that's not what the insurer intends in the Supreme Court's view, it's what the policyholder intends. And then the effect of the policy as applied to the relevant factual situation. Now, I've certainly already seen quite a lot of concern that this actually brings hindsight into the interpretation of the policy. And that is indeed what the Supreme Court is doing. They want to get these policies to respond, although the insurers are following the law and their wordings are entirely appropriate. There is no way that this is actually bringing hindsight in unless the Supreme Court wants it. And I have to say that this is quite worrying. Background knowledge is important, but it doesn't suggest that the insurers are expected to revise their position as a result of what we now know to be the case. And I think it's important, as Chris was saying, to remember that this alteration is going to have fundamental business consequences for those who insure in this area. And the court appears to have ignored that, ignored the importance of giving a level playing field and a stable market so that people can enter into contracts with certainty. Chris.
Thank you. So I'm just going to have a quick look at causation now then, because the High Court, having found that almost all of the policies responded to some degree, and the Supreme Court having found that even more of the policies, more policies responded more fully, this is perhaps then where the next issue will lie for the relevant insurers who are on the hook perhaps for these claims, and that's around what the court's got to say about causation. The words or phrases that I got on the slide there in italics are examples of the words or phrases used in the policies to refer to the causation type issues. And the insurers are saying, we will indemnify you against particular losses caused by particular risks, if those risks crystallize. And the court's taking us through its thinking, or at least it's trying to take us through its thinking on what the right causation test should be then in these cases. What it's actually done though is it's almost like an academic textbook. If I was an objective reader might say, well, what it's doing then is it's looking at all of the different ways in which, from a legal perspective, you might assess causation. You might work out what's been caused and what hasn't, and you would go through some of these approaches. Well, the court's gone through them one after another, and pretty well said, no, it doesn't really work here, doesn't really work here. So the normal starting point would be, well, what was the closest thing? That's probably the thing that caused the loss. Is that the thing that was insured against? Has that triggered the indemnity? What happens if there's more than one cause and one of them's insured and one isn't? And so on. You see, then over the best part of 100 paragraphs, the court's gone through all of the traditional approaches to these things and dismissed them one after another. Not perhaps clear then whether it's doing that because it's trying to find the right legal basis for what should be covered and how much should be paid, or whether it's really doing it because it's trying to find a way of reaching the conclusion that it wants to reach for policy reasons. My own suspicion is that actually we're closer to the latter rather than the former but we'll see how this develops over time. But the practical consequences are here, or the practical results are here. And what the court's done is take 3 examples of the causation wording from the policies, if you like, and then told us what it thinks about them. This one comes from one of the Hiscox ones, and you'll see that I've put in the numbers 1, 2, 3, and 4 there. The court's saying then, well, practically speaking, for these particular policies, if all 4 elements are present, the indemnity is triggered and the insurer must pay. So in this case, the insurer is only going to have to pay for losses resulting solely and directly from an interruption to your activities. Interruption doesn't quite mean what we used to think it meant, and we can come to that. It'll also have to pay them only if those particular losses have also been caused by an inability to use the insured premises. Inability, again, doesn't quite mean what we thought. Due to restrictions imposed by a public authority, restrictions imposed again wider than we thought, following an occurrence of a human infectious or human contagious disease, which we might not have thought covers COVID, but now does. So if all 4 of those elements are there, the insurer, this insurer, Hiscox, would have to indemnify for those losses. This has been the law for some time. So in the second bullet point there, the sub-bullet point, the court is confirming what we already knew, that if there's a concurrent loss, something else which has also caused it, that doesn't matter if that other cause was uninsured, because the policy must still respond. The position would be different, though. If the other cause was excluded, then the policy probably wouldn't respond. And then this is the only case, actually, the only example of the wording where the court says what happens if the sole proximate cause was COVID, but not in a way envisaged by the insuring clause there. And it gives an example. This is the only example they give. But this particular policy in this example wouldn't need to respond if the travel agent was the policy holder and the travel agent had suffered a loss of business, but it wasn't because of interruption to the activities caused by an inability to use the premises due to restrictions imposed by a public authority. It was because of travel restrictions. So not because the government had closed the shop, but because the government, instead of closing the shop, had stopped people flying, and therefore the business was lost. This policy wouldn't cover that loss because that's not caught within this causation clause. We can see then that despite the court's best efforts, some claims still won't be paid, or they won't be paid in full, and the causation clauses, as I'm referring to them here, will be one of the ways in which insurers will still be quite lawfully and properly entitled to restrict or avoid payments where that's, of course, the right thing to do. We've got 2 other examples here. There's one there from an ARCH policy and one from an RSA policy. The court's just making the same points on each of these, though. So in the first one, that ARCH policy will only respond if there's a reduction in turnover or increase in the cost of working because of a prevention of access to the premises due to actions or advice of a government or authority due to an emergency. So that policy won't respond if the business suffers a loss for some other reason. We've got to have all 3 of those tests met before that policy will respond and before it will cover those particular losses. And the same thing happens in the second one, the RSA one. It's only going to respond if there's a loss as a result of a closure or restriction as a result of COVID at the premises or within a radius. Some of that we already knew. Some of it is undisturbed by this decision. It's one of the reasons why I think then that despite the headlines, some policyholders won't be getting a payment for all of their claims, the whole of their claim, and some policyholders might not get a payment for any part of their claim.
Thank you, Chris. I think I've already mentioned the fact that my concerns are that the way in which the Supreme Court approached this was not in line with normal legal approaches. And I said that I was looking at this very much from a lawyer's point of view. I was talking to a number of insurers yesterday, and this came up, and I said, to me, this is legally a real problem. And they were saying, well, fundamentally it's business and we've already reserved for it, or we've already looked to our reinsurers. We're not that bothered anymore. That, of course, I can totally understand. But my wailing and lamenting was greeted. I talked to them about the issues on this clause, and certainly they were howling with laughter by the end of it. As I've said, all the insurers can't be wrong, and what they did was, to a large extent, relied heavily upon the Orient Express case, which is how they started approaching the case. One of the quite interesting things about the Orient Express case was that a number of those judges on the Supreme Court bench had decided that case either sitting on the arbitration panel or in the case itself when it went to the High Court, the Commercial Court. The Supreme Court considered that Orient Express was wrongly decided. So essentially they're marking their own homework and finding it lacking because of the fact that the hurricane damaged both the hotel and the surrounding area. The hotel damage was covered, but not the loss of business, because nobody was going to New Orleans at any point after Hurricane Katrina. And I think we all thought that the Orient Express case had its problems, and I suggest that it might mark the high point of insurer-friendly court decisions. But given that the various Supreme Court judges were involved, they quoted a number of learned articles and thoughts that Orient Express was wrong. And then they started quoting a number of authorities which showed that courts can change their minds. And they quoted a US person. And at paragraph 312, they go, "We likewise invoke whatever ways by which we may gracefully and good-naturedly surrender former views to a better considered position." That was the bit that sent my clients and contacts into hysterics. I think this is really poor on the part of the Supreme Court. They are backpedaling on Orient Express, which many of them had been involved in. And to what extent this then caused me to consider whether or not this was actually going to be an impact, not just on these BI test cases, but having now said that Orient Express was wrongly decided, what about all cases which happened between this decision being handed down, the Orient Express one, and the Supreme Court decision? At the end of the day, as they're backpedaling on the way in which we interpret the BI policies, what scope is there for challenging interpretation of the others? Because let's face it, I could understand that they want to say Orient Express is wrong, and from that date going forward, cases of sort of insurance claims can be seen in the new light. But it's pretty bad to go, oh well, everybody who was following the Orient Express case was misled because we got it wrong. And so now we're saying, sorry, we got it wrong, and we're going to find in favour of the policyholders here. I do think that this is something that worries me intensely, because I would say, how could all the insurers be wrong when they were following existing case law? And this is something I know that Chris thinks I'm rather over-egging the pudding on suggesting market stability is being challenged by it. And it's true. I don't think, and as my contacts and clients have said, we've reserved for it. We've got the reinsurance. We're not worried in the same way that we once were, because, obviously in March, there was a lot we didn't know, and we know a bit more now. But it seems to me that by driving a test case and getting the result they wanted, with the Supreme Court performing somersaults, frankly, to get there, the FCA may have opened up a further can of worms that they didn't expect, with deciding that they're going to challenge all the meanings of insurance law, and they're going to say that we can't follow pre-existing decisions because there might be a danger of the Supreme Court going back on itself. Chris?
Just before I move on, I think you're right, Pollyanna. This is shameful to me. I've got two things in my mind as I say that. The first is that reports in the last few days about the cost of meeting the claims just for the BI policies are expected across the industry to be about £2 billion. That's the first thing. The second, of course, is that the cost of the litigation itself and the uncertainty has been enormous as well. That's not to say that it all depends on what's been decided about Orient Express, but of course some of that is generated directly by the about turn on Orient Express. And what's happening here is that we're talking about the lead judgment, which was prepared by two of the judges and agreed with by the third, and the two that prepared it and delivered it are two that were involved in Orient Express in different ways and at different times. But really what they're doing, and they spend most of a page doing it as you've just described, chuckling to themselves about all the different ways in which you can say, sorry about that, got that wrong, didn't I? Changed my mind, not to worry, let's move on here. And that paragraph 312, you've got some examples there of the ways in which they say, we're just resigning from that, but they don't attempt to explain really, I think, how they've got it wrong, and they don't do anything which suggests that they recognise the consequences of the change of heart, nor all of the things that have depended on it in the meantime.
Exactly.
So there we are. So I suppose before we move on then to lessons learned, we might just sort of pause and think about what this, how best perhaps to view this decision. The first is that in the courts then, the court itself, the Supreme Court, has said that it thinks that this is a testament to the success of the test case scheme procedure. And I suppose it is in one sense, which is, well, the FCA wanted to get a lot of things tested quickly and to get a decision quickly from the most senior court in the country, and that's been achieved in 7 months. So in a sense, that's a success. We've got it all very quickly, and we managed to bang lots of different insurance policies and insurers into one set of claims and push it all through very quickly. So that is a sense a success. To my mind, it's also highly unsatisfactory though, and I say that because to push all of that through so quickly, we've had to take a very, very high level approach to dealing with the issues, and that means I think that we haven't really properly considered any of the particular policy wordings or what they really did. You will remember as well that in the High Court there were 8 days of hearing, but 4 days were taken by the FCA at the beginning. The 8 insurers that followed got 1, 2, 3 hours each between them. Sometimes they had, I think, 3 days between them, and they got an hour or 2 or 3 each to say their piece before the FCA got another day. And that's an incredibly quick rush through at an incredibly high level to deal with some very complex issues with some very far-reaching consequences. So I think reasonable people could reasonably disagree about whether that's really been a success. The second thing I think maybe then that anybody who's involved in this might not recognise is the idea that it's certainly true that there's been an immense amount of work has gone into this, and a huge amount of cost. I'm not sure though that many people who were involved in this, either directly or affected by it, would regard it as proceedings conducted in a cooperative and constructive manner. You'll all know, of course, that we haven't been involved in the direct litigation, but we've been talking to many insurers that were, and we've talked to others who are indirectly affected by it because they also do business interruption insurance. And I haven't yet spoken to anybody who thinks that the FCA was cooperative or constructive. Rather, it seems to have been bullying and aggressive, setting unrealistic deadlines, demanding information, expecting things on weekends, on religious holidays, setting deadlines for itself and then not meeting those, although it's very grumpy if the insurers don't meet the deadlines set for them. The third thing might be then, well, how do we look at this decision in the round? What impact might it have for the future? We won't know until we start to see how other policyholders or insurers deal with this decision in litigation in the future and how the courts respond to it. our initial thinking, I think it's right to say, certainly my initial thinking is that this is unlikely to be a binding authority, in the main anyway. There are one or two bits that I think people might try to rely on, but it's looking as if it might just be a decision on its own facts, or a decision for the Times, a policy decision and nothing more than that. I'm sincerely hoping that that's the result, but it's going to be a while before we know. But if it's a policy decision, then people in the future will look at it as, well, that was then, this is now, but let's apply the law. Let's not worry too much about that particular decision. That's all more easily said, of course, and it's going to be quite some time before we know whether that's really true. And that makes me think that this isn't just a decision for Christmas. This is one that might last for some considerable time before the dust settles and we really know what the consequences of it are. And even if it is just a one-off, there are certainly some things to learn from it. I'm just going to talk then through some of the things that we might take away from it, that are likely to be helpful to insurers and reinsurers now and in the future. And Pollyanna's got some more as well. The first thing I would say is that one of the particular problems, one of the ways in which the courts are able to get into these policies and unpick them and criticize them and then almost set them aside was because they were, in some cases, very, very long policies. And they'd been built up over many years. You would have a policy, then you'd have an extension, you'd have limitations, you'd have exclusions, and this meant that we were constantly bolting bits on. Sometimes there were gaps between those bits, sometimes there were inconsistencies, some things just weren't properly dealt with, and the consequence of that was that the courts were able to say, well, in this page you say this, and on that page you say that, we prefer this one. So one initial lesson is likely to be that it's probably going to be better in future to have a series of smaller, complete and distinct policies, even if that means that you have lots of common terms or boilerplate that appears in each policy, rather than having one very, very large policy that all covers all sorts of things with an extension here and a limitation or an exclusion there. The key lesson, I think, must be to get the insuring clause right. So use the insuring clause itself to properly delineate what it is that you mean to cover and to properly exclude what it is that you don't mean to cover, so that you don't need to say anywhere near as much. You don't need to rely anywhere near as much on either limitations or exclusions. And just picking up on those things then, what we see the court doing is in one case, I think it was an RSA case, they say, well, the insuring clause is on page 30 something and the limitation or the exclusion is on page 90 something. And because we're looking at this and thinking about what the parties reasonably might have understood, but we recognise that the policyholder is an SME, well, he or she probably only got as far as the insuring clause and then gave up. So they wouldn't have realised, of course, that the limitation or exclusion was on page 93, and they wouldn't have thought that it was intended to undo or limit or restrict even some of the insuring clause. And so those sorts of things were able to allow the courts in again. It gave them an opportunity to ignore exclusions and limitations to the detriment of the insurers. Where you do need to draft an exclusion, and of course there will be times when you do, if you're drafting it for a notifiable disease or something of that sort, start with the ecclesiastical wording and the High Court's commentary on it, because one thing we do know from this decision is that the ecclesiastical wording worked. And then, as I've already said, if you get the insuring clause right, you don't need to cut back or using exclusions or limitations. That will be better. I say that partly thinking as well that in one case the court said, here's an exclusion, but the first word of the three words in the exclusion removes so much of the insurance that you can't have meant that, so we'll ignore that. And if you can't rely on the first word of those three words, you can't rely on any of them, so we're going to ignore the rest too. And that meant then that one of the particular insurers there, I think RSA again, had a problem. If you do need exclusions and limitations, just practically speaking, don't put them too far away from your insuring clause. Try to keep them close. And unless, of course, they're immediately following or adjacent, it's probably worth including express cross-references backwards and forwards. So the insurance clause expressly says this is subject to exclusions and limitations at paragraphs or on pages. And then when you get to the limitations and exclusions refer back to the insuring clause, so that some of those, I'm sure he didn't read that far and wouldn't therefore have realised type issues don't arise. Some of what we're talking about here, of course, is about notifiable diseases and insurance that responds or insurance that excludes notifiable disease type risks. And so it's going to be obviously indirectly relevant for business interruption insurers, but also I think public liability and occupiers liability and wedding and events policies. But quite a lot of these things will be relevant for all sorts of policies, especially the longer policies, the more complex ones. And then some of the words on the screen here, or some of the phrases on the screen here, we now know don't quite mean what we thought they meant. And I'll just run through them quickly, but it's well worth keeping these sorts of things in mind as well if you're drafting a policy. It's now clear that a disease will have been sustained by a person if they have it, whether or not they have symptoms of it, and whether or not they've had a test which shows that they had it. And a disease will have been sustained by a person within the boundary, within the property, or within the perimeter of the property. If that person wanders into the property or into the area, so in other words, where we might have thought before that a person sustained this illness because they got it at or near to the property, that's no longer true. They can literally wander in, and that can be enough to trigger something. A number of the policies included definitions of notifiable disease. That defining notifiable disease in anything other than saying has the meaning given to it in this statute and those statutory instruments is probably a waste of time. The courts in particular said, although this exclusion defines notifiable disease and this disease might have fallen outside of that, it said, but anybody would have understood by notifiable disease that what everybody had in mind was what was defined in the statute and the statutory instrument. So we're looking at that instead. Manifested is slightly different. That a person will only manifest a disease if they've got symptoms or if they've been tested. So that's perhaps helpful. Interruption comes with what might have been a surprise. Many people used to think that a business was only interrupted if it stopped, however briefly, but it now appears that the business will also be interrupted if it's restricted in some way or limited. So it doesn't have to stop, it might just be reduced. And then due to restrictions imposed, as Pollyanna mentioned early on, restrictions can be imposed apparently by the Prime Minister giving a speech or by the government issuing guidance. So if you want your policy only to respond to interruption, which means it's stopped, you're going to need to say so expressly. And if you want it only to respond to restrictions imposed that have a force of law, you're going to need to say so expressly. Otherwise, this decision is likely to cause you some problems. The same can be said, of course, then about closure or restrictions placed on the premises. Say for one thing, perhaps, which is that the insurer that used those words or that phrase might perhaps have thought we mean the closure of the whole premises, but the court's very clear that actually a restriction on part of the premises or part of the use of the premises or the closure of part of the premises for some purposes would also be caught. And the result of that is that if you have a business that sells takeaway and sit in and eat food, and you can't do the sit in and eat, but you can do takeaway, well then your policy will still respond to the loss of the sit in and eat business when you might have thought as the insurer that it would only respond if the whole thing was closed altogether. Enforced closure and inability to use have similar issues attached to them, and so in fact as prevention of access, these things aren't as absolute as they might otherwise have appeared. So if you want them to be absolute, if you want to be clear about exactly what they do and don't mean, it's well worth using some extra words to make the position unavoidably clear. Pollyanna.
Thanks, Chris. I think what seems clear to me, even if it doesn't get to the industry, that there is a need to readdress what your policies say. Chris has highlighted the changes to the words which the Supreme Court and the High Court decision, Commercial Court decision, make. And there have been some suggestions that the results might have been different if the wordings were more restrictive or there had been clear exclusions. To some extent, as Chris pointed out, some of the Supreme Court bases for deciding that exclusions didn't apply because they were 60 pages away from the insuring clause and hadn't been cross-referenced is shocking. It is important to remember that what is happening here is a wishful interpretation of some cases which, frankly, with an exclusion that is clearly stated, should work. And they've looked at some of the consequences of the exclusions. And indeed, I've considered that actually get your insurance cover clause correct and only then rely on exclusions. You'll need exclusions, but it's absolutely crucial that those exclusions are clear. And as Chris said, we discover that they are actually cross-referenced so that an insured is going to be able to see what the exclusions are. I always advise insureds to look at the exclusions because, to my mind, that's absolutely crucial, but it's quite extraordinary that the Supreme Court felt able to ignore them. And finally, Chris mentioned this issue with the list of insured diseases, the notifiable diseases, where they are listed. And of course, some of the policies do actually refer to this. They list the diseases. And it seems to me ever more futile to do so, frankly, because you're always going to get another virus come along, which isn't COVID-19 or whatever your last one was. So while I look at those policies which refer to SARS, which refer to AIDS, and think, that was clearly revised in 2000, 1900, whatever, it doesn't make sense to ignore the fact that the Supreme Court has said a notifiable disease is obviously one that is on the regulatory list, regulation or the statutory instrument list. And I think that actually is quite helpful in terms of clarity. And excluding anything from COVID-19 is obviously quite a successful way of approaching it. But there are other statutes that bring it back into force, which means such as employer's liability, where an employer has a duty to maintain the health and safety of its employees. And it would be a bit of a clash to suggest that the BI case, which the BI policy, which removes anything coming out of COVID, removes the employer's liability to look after its employees. So I think that you have to remember that there are other insurances, including those that Chris mentioned, which will be impacted by this. Chris, could you bring up the next slide?
Okay.
So the really interesting thing is where we go from here. We have received some questions from people while in this, and there's definitely been a question about the first two. And how do I feel, how do I think that the reinsurance responses are going to pan out and whether or not there's going to be litigation? As I said, the impression I've got from the industry is that the insurers, the first port of call, are relatively sanguine. What I'm beginning to hear is some concerns from the reinsurance community. The issue of following the fortunes and so on now looks really quite worrying. BI insurance has quite often been done on a loss leader basis, or at least not a hugely profitable basis. And I think that's important here because we're talking about an insurance that will respond. And I know the BBC website, which is clearly policyholder friendly, has said that even if the Supreme Court's decision is in favour of policyholders, many of them will already have gone bust. So there's some issues around here that no one's going to be particularly happy about this decision. The key point is that I think the market decided that early on it was going to insure that as much risk as possible was going to be settled with the reinsurers. And secondly, certainly on the insurers I've spoken to, some of them underwrote and put reserves aside to deal with COVID, and others didn't. And it's quite interesting to see some questions as to whether people really understood what this disease was going to do at the outset. Those who determined that it was simply another flu bug have been found out, as it were, because of the huge spike of extra deaths in April and May. But I think it's important to remember that the way the market works is that it's going to be a few years, as Chris said, to see how it all pans out. But I do think that there's going to be some litigation with the reinsurers who may not respond quite as the market expects to these claims. The other thing is, quite clearly, there are issues around wordings. I think this case means that no longer will insurers be quite as sanguine as accepting all the brokers' wordings. I think there's probably cases where there may be cases against people who've advised on the wordings and have found them wanting. There's, on the one hand, those who say, well, Hiscox responded, so why didn't you get me a Hiscox policy, to their brokers. Equally, there's going to be some issues where the insurers adopted the broker's wording and then found it wanting. And now are they going to start suing the brokers for putting in wording which means that they've got to pay out when they could have had wording provided by somebody else who didn't? I mean, quite clearly, we've suggested using the ecclesiastical as a starting point. And talking to people in the market, I discovered that the ecclesiastical had actually spent quite a long time on their wording, and they'd actually paid for it to be done. And fascinatingly, the Supreme Court criticises the clarity of the ecclesiastical, the High Court criticises the clarity of the ecclesiastical wording, and although they found that it worked. So there is an element which we could refine here. And yes, I do see that there's going to be some possible fallout for both solicitors and brokers, with potential reverse claims for contributory negligence on the part of the insurer who assumed it. But I think this is something that, again, we'll find out in the years to come, but it's definitely something I would think of. And I think it's also time to start taking back the wording under the insurers' underwriters' control, because to the extent that it seems the case in the market that insurers rarely get to impose their own wordings and the brokers seem to do it, we now know that this is actually something quite dangerous, and that the insurers are going to need to be a bit more proactive on getting their wording sorted. And then finally,
sorry, I didn't mean to interrupt. Go on.
Just finally, just to say that we've talked a lot about this being a policy-based decision. And right at the beginning, when it started, a number of insurers were coming to me and saying, this is the government trying to get the insurance industry to pay for the pandemic. We cannot do so. We don't have the cash. We don't have the capital to enable us to do so. But it seems to me to be part of the whole approach by government to getting the insurance industry to pay for things it doesn't fancy paying for itself. So, for example, we're looking at the test, they call for evidence on Solvency II together, Chris and I, and the infrastructure investment programme and green climate change programme are clearly being seen and earmarked as something that they can get the insurers to pay for. I just wonder how many insurers would be pleased about paying for a HS2. Chris.